minutes to make its oral argument. If you're the appellant, you've reserved rebuttal time, you'll receive your rebuttal time after the appellee makes its argument. We do not anticipate any technological problems, but if any were to occur, please just stay calm and stay with us, because we will work those out and we'll be sure that no one is prejudiced by that. Before, I also want to remind everybody that this oral argument is being live streamed over the internet. So just for your edification, please keep that in mind. Finally, I want to introduce our panel for this afternoon. We have Judge Arnold Golden from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
You may call the case then.
Jonah Paul Anders versus Mayla C. Anders.
All right. Mr. Anders, I understand that you are representing yourself. Is that correct?
That's correct, Your Honor.
Okay. Let me say a couple of things before you get started, and then I'll let you say whatever you'd like. First of all, you understand this is not like a trial court. What we will do is we'll hear your argument, we'll hear opposing counsel's argument, we'll take this matter under advisement after we've heard from you, and we will render a written decision that hopefully will be out in the next 60 days or so. So don't expect an immediate result today.
Yes, sir.
But you've got your initial argument time, and then you've reserved, I believe, 5 minutes for rebuttal. And you have any questions about the procedure before we get started?
No, sir. Thank you.
We will hear from you then. If you would, please just introduce yourself to the court and then proceed into your argument.
Well, thank you, Your Honor. Good afternoon to this honorable court. My name is Jonah Paul Anders Sr. I'm the appellant. I'm an honorable discharged United States Marine veteran and a small business owner in Shelby County, Tennessee. I would like to show that a major error was made in my PO case, now before this honorable court, 3-judge panel. I would like to show that I have been denied a fundamental due process right and equal protection under the law, the right to be heard in open court by both the Tennessee Constitution as well as the United States Constitution. The Supreme Court rule of judicial conduct ensuring the right to be heard, Rule 10, says a judge shall accord every person who has a legal interest in a proceeding that they may be heard and are either represented by their lawyer. The merits of this case, Your Honors, is dealing with a divorce versus an annulment. In January 28, 2015, the late Judge D. Army Bailey, first action at the inception of this case was a status conference, which he ordered both parties, the plaintiff and the defendant's counsel, to submit a memorandum of law showing the difference between a divorce versus an annulment based on Tennessee law. That was in February the 18th. They had to get the memorandums of law in. My attorney at that time did get her memorandum of law in on February the 18th. The defendant's attorney did not file hers until July the 23rd, 2015. At the same time period, the late D. Army Bailey on February the 18th, 2015, received an epistle authenticated certificate proof from the Court of the Philippines showing that the defendant never received an annulment from that court. That exhibit was filed in the record on February the 18th, 2015. In fact, the defendant had committed bigamy in the certification that came from the court, directly from the court there to Judge Bailey. Fact number 2, the plaintiff, I was deceived by the defendant that she was truly annulled from her previous marriage because I cannot marry someone that's already married. However, the memorandum and fact finding, it showed that the defendant was untruthful and also she was very deceptive. Now, after the passing of the late Judge D. Army Bailey, The case was moved to Division 4 to the Honorable Judge Gina Higgins. Although the information and the fact finding of the certification proof from the Court of the Philippines that was made available to the Division 4 clerk, Judge Gina Higgins. However, this clear and convincing evidence was never entered into as part of the discovery to expose the truth about the defendant's fraudulent documents, that she entered into this court record that she was annulled from her previous marriage. If this kind of unscrupulous, frivolous decision prevails, then it would be an attack not only on the American people, but the rule of law and the Tennessee Constitution, as well as the United States Constitution. The circuit court erroneously treated my claim for an annulment and a divorce as the same, yet the law clearly makes the distinction between the two, because an annulment is a remedy for avoided marriage from the beginning, while a divorce presumes that the marriage was legitimate. Now, because I was entitled to have my separate cause of action for the annulment heard by the court, and the court declined to exercise jurisdiction over this cause of action, the circuit court therefore abused its discretion by refusing to allow my preponderance of the evidence, clear and convincing evidence, that the defendant's documentation were fraudulent based on the Tennessee rules of evidence and also Tennessee state law. Tennessee state law, Tennessee divorce alimony and support custody 15.4, second edition, notes that an annulment and a divorce are two distinct causes of actions. Also, Tennessee Annotate Code 36-3-102 states that a second marriage before dissolution of the first is prohibited by law in the state of Tennessee. A bigamous marriage is void from the beginning. It is never like it's never happened. Brown versus Brown, the Tennessee appeal case was in year 2000. It classified marriages prohibited by law as void from the beginning. Gordon versus Pollard, another case before the appeals court in Tennessee in 1960, recognized that a marriage prohibited by statute is void as if it's never been. Bigamous marriages, for example, are void from the beginning because they are prohibited by the statute. Again, Gordon versus Pollard. By granting a divorce, the trial court made a legal mistake that caused harm to me and my family as well. After the inquiry and the finding of facts by both the defendants, a counsel, as well as the plaintiff, both attorneys concluded in their memorandums of law, Your Honor, that Mayla Anders committed bigamy. The appealee has been diminished. I have been impaired. I have been abridged by these horrible, immoral, and corrupt actions by this appealee against me and my family as well. I respectfully ask this honorable court, three-judge panel, to make me and my family no less than whole. Therefore, I respectfully pray that this honorable court, three-judge panel, to grant this appealee an annulment from this bigamous, otherwise invalid marriage and any other further relief that this honorable court deems proper for me and my family. And I ask you to reverse this decision to allow me to be heard according to the law and allow me to be made whole. I have at this time concluded my statement before this court and would like to answer any questions with the remaining of the time that I have that the judges may have for me.
I see no questions, Mr. Anders, so we will hear from the appellee. You have your rebuttal time.
Thank you, Your Honor.
Yes, sir.
Good afternoon.
Good afternoon.
May it please the court, I am Teresa Patterson. I'm the attorney for the appellee in this case, Mayla, now known as Kasakop, formerly known as Anders. I have done my best to address the issues raised by Mr. Anders in spite of his inartful pleadings. I narrowed the issues in my brief to the first issue being whether the court erred in granting a divorce to my client as opposed to granting Mr. Anders' request for annulment. I would point out that Mr. Anders in his argument seems to suggest that the court did not consider his request for annulment. The court's final decree of divorce clearly indicates that she did consider granting the issue of whether she should grant an annulment or a divorce. And she concluded that based on the documents that were presented by both parties, that she did not feel that either party's documents were reliable, and that the marriage basically in Las Vegas, Nevada was valid, and therefore she granted the divorce. As far as compliance with the right to be heard, I was not the attorney at trial. There is no transcript, but it appears that the parties had a full day's trial. Mr. Anders was given ample opportunity to provide testimony and evidence, and that testimony and evidence simply did not persuade the court to grant his request for an annulment. As far as the remaining issues that I believe I gleaned, at least from his brief, he alleged that the court did not properly consider the award of child support to my client as set forth in my brief and as set forth in the court's final decree. The court found that Mr. Anders' testimony with regard to his income was not credible. This was an initial child support setting pursuant to the guidelines. The court, if a party does not provide reliable evidence of income, can impute income based on the average earnings of a man in Tennessee. And based on that guideline, the court concluded that the child support was properly calculated and imputed income to Mr. Anders. The court also relied, as far as the wife's income, on the findings of the divorce referee in a previous temporary support hearing. So the court's determination of child support was proper, and there was no abuse of discretion. Mr. Anders also alleges that the court did not properly award alimony, that being based, I think, on the fact that the court found that the parties had a valid marriage and granted a divorce. I would point out that the court did go through several of the factors set forth in the statute to determine whether alimony is appropriate and what amount should be awarded. And there was no abuse of discretion. The court did follow the statutory factors in reaching the conclusion that an award of alimony was appropriate. Mr. Anders also alleges that the court erred in awarding marital property to wife. The court also considered the statutory factors in an appropriate award of marital property, and in fact awarded Ms. Kasakop, Ms. Anders at least, awarded her a vehicle. I would point out to the court that subsequent to the entry of the final decree, there were post-divorce matters in which my client returned the vehicle to Mr. Anders. So I would state that there was no abuse of discretion in the court's determination, and that if there was an abuse of discretion with regard to awarding of the personal property, that property was subsequently returned to Mr. Anders. So that would be harmless error, if any. I did want to address the court did not feel that she could comfortably rely on the documentation from the courts in the Philippines. And Rule 901 with regard to self-authentication of the documents, even if the documents appear to have been met those requirements under Rule 901, that doesn't mean that the court has to rely on them or believe them. It simply suggests that those documents should be properly admitted into evidence and considered by the court. Those documents were admitted into evidence. As far as I can tell, there are no exhibits and there was no list of exhibits, but I think from the court's language in the final decree, she considered those documents and she did not find them reliable and did not feel that she could base a decision to grant an annulment on the documents that were submitted. That is not an abuse of discretion. I think that the law in the state of Tennessee is that the courts, whenever they can, should find that marriages are valid and not invalid. So based on those arguments, I think that I would ask that this court deny Mr. Anders' request and deny his request and affirm the judgment of the trial court.
You said you did not, that there is no transcript of the evidence. Do we have a statement of the evidence?
No, Your Honor, there was no statement of the evidence presented, and I was not the trial attorney. This appeal actually it took several months for the court to enter the final decree. The appeal was filed. Then subsequent to that, there were post-trial motions. There was a remand, and this trial was actually, the final decree was actually entered on October 28th, 2016. So there's been a quite span of time.
I just was trying to determine what we had in the record besides the pleadings. But thank you.
Yes, sir.
Anything else you'd like to say? You still have time remaining.
No, I think that covers what I perceive to be the main the main issues that have been raised by the appellant. It is somewhat difficult to discern from the various pleadings exactly what the specific error he is alleging on the part of the trial court. But I believe that I hit the high points, and I don't really have anything to add.
All right. Thank you. All right,
Thank you.
Mr. Anders, you have 5 minutes in rebuttal time, sir.
Well, thank you, sir. And I would like to say the trial court did abuse its discretion by awarding the wife a divorce from the husband because the trial court declined and refused to accept jurisdiction with regards to the setting aside of the marriage annulment and declaring that it was fraudulent and not considering the undisputed proof that the appealee or the defendant was still married and is still married to this day, Your Honor, to her previous marriage. Fact, the trial court did err and abuse its discretion by allowing the applicant any jurisdiction or any forum for me to present my clear and my undisputed, clear and convincing evidence showing that the appealee has committed bigamy to be heard in a judicial setting, therefore denying me my basic due process and equal protection of the law. I would like to quote for this court what was said by the Honorable Judge Gina Higgins out of the transcript that is recorded in the record on her ruling, March 8, 2016. Quote, the court takes into consideration this was a Nevada marriage. The court has declined at this time to accept any jurisdiction with regards to setting aside of the marriage annulment and declaring it was fraudulent. The court cannot make a determination regarding the allegations of fraud and declines to do so at this time. Emphasis added by me. The judge had the information, clear and convincing evidence. It meets all of the rules. The rule of evidence is according to the Tennessee law. It had the signatures. It has the apostille. It's a country that we recognize as a treaty country. And it is clear proof that this lady is still married. The late Honorable Judge D. Army Bailey ordered and received undisputed proof of the bigamy by the appeals court. Out of his mouth, the first thing that he said in the courtroom was, Mr. Anders has said this marriage is fraud, and he wanted to get to the root of the matter, and he wanted to have he wanted to have both attorneys to prepare the memorandum of law. They did. The Honorable Judge Gina Higgins advised me, the plaintiff, if I wanted to attack this fraud, attack it. And I did. I took her advice. I attacked this in the trial court of the Republic of the Philippines, hired an attorney at great expense, Department of Justice in Multilupa City, where her purported documents came from, showing that she was annulled. And this is what came out of that: a resolution and an indictment with charge of falsification of public documents for marriage fraud. which is recorded in the Shelby County Court, October 15th. Second fact, the apostle order of arrest for this lady from the Metropolitan Trial Court presiding judge there in the Philippines, also put into the record. The third fact, an apostle arrest warrant issued by the same trial court ordering arrest for this lady has been issued, an alias order for her. They're trying to locate this lady because she's a fleeing fugitive. The appealee and her daughter are now both in removal proceedings, Your Honor. They both are being in removal proceedings by the Department of Homeland Security as well as the immigration. The only reason they're still here in this country is because they moved the COVID cases forward, which is in January. The next fact, the appealee and her daughter, permanent resident, have been terminated in March 13, 2019 because of this same thing before this court. And I'm asking this court, therefore, based on this information, and that this lady is fleeing a fugitive, she's trying to avoid being held accountable for her actions. Therefore, I respectfully pray that this honorable court, 3-judge panel, grant me an opportunity to have my annulment heard from this bigamous, invalid marriage and any other relief that this court deems necessary. I ask this not only for myself, but I ask this for my family as well, that you reverse this decision and allow us to bring this thing finally to a close. I thank you very much for your time and consideration by this honorable court.
All right. Thank you for your arguments. We will take this matter under advisement and attempt to render an opinion at the earliest possible time. We appreciate you participating by Zoom. Ms. Angie, if you would recess court to the call of the docket.
This Honorable Court of
Thank you, Your
Appeals
Honors.
stands adjourned.
Thank you again, Your Honor.